What if one quiet date on the calendar could suddenly turn thousands of lives upside down in California? According to recent enforcement data and policy trend reports, immigration removals linked to technical violations have increased sharply, and officials have identified February 15th, 2026 as a key compliance checkpoint. What's truly alarming is this: many of the people at risk are not new arrivals. They are workers, students, caregivers, and families who believed they were safe because they've lived in California for years. No raid, no warning, just a system update, and everything changes overnight. Here's where the fear really sets in. Most expulsions don't happen because of serious crimes. They happen because of missed paperwork, expired permits, old addresses, or rules that quietly change without headlines. A visa overstayed by a few months. A work permit renewal delayed. A court notice sent to the wrong address. These small details, often ignored, are now being rechecked through advanced data systems, pulling people back into enforcement zones they never expected to face again. If you live in California or know someone who does, this isn't just news, it's a warning. Stay with us, because by the end of this video, you'll know exactly who could be affected, why February 15th matters, and what steps can protect you right now. Subscribe now, because one click today could save you from a life-changing mistake tomorrow. Number 1, visa overstay. For years, many people believed that overstaying a visa was only a problem if it happened recently or involved serious intent. That belief is now dangerously outdated. Under new enforcement priorities tied to February 15th, 2026, visa overstays, whether they happened last year or a decade ago, are being re-evaluated through upgraded federal and state data systems. This means someone who entered legally, built a life, found work, and raised a family in California could suddenly be flagged, not because of what they did yesterday, but because of what they failed to fix years ago. The shock isn't just a rule, it's how quietly it's being enforced. What makes this especially alarming is that many overstays were unintentional. Students who waited for status changes, now workers whose employers promised to handle the paperwork, visitors who stayed during emergencies and never realized the consequences. In the past, these situations often stayed buried in old files. Now, automated cross-checking systems are pulling entry dates, exit records, and visa classes into one place, creating a clear digital trail. If the system sees a gap, it doesn't ask questions. It flags first. And once flagged, immigration review can begin without warning. Even if you've had no issues for years, here's the most important truth. A visa overstay does not automatically mean removal, but ignoring it might. People who act early often have options, adjustments, waivers, or legal protections, but those doors close fast once enforcement starts. This is why understanding your exact entry date, visa type, and current status is no longer optional. It's survival knowledge. The most painful stories we see are not from people who broke the law knowingly, but from those who assumed time alone would protect them. In 2026, time doesn't erase mistakes, records remember them. If this reason hit close to home, comment, check status below, and subscribe, because we pour our heart into warning people before it's too late, and one click today could protect your tomorrow. Number 2, expired work authorization. For many immigrants in California, a work permit feels like safety. It's the document that allows you to earn, pay taxes, support a family, and live without fear. But here's the harsh reality most people don't realize until it's too late. An expired work authorization can quietly push someone out of legal status even if everything else in their life looks stable. As February 15th, 2026 approaches, immigration systems are paying far closer attention to expiration dates, and the margin for error is shrinking fast. A single missed renewal can now trigger a chain reaction that pulls someone into enforcement review. What makes this situation especially dangerous is how normal delays have become. Processing backlogs, mailing issues, employer mistakes, or simple confusion about renewal timelines have left thousands of people working under the assumption that pending means protected. In the past, officers often showed flexibility. Today, digital verification systems don't see explanations. They see dates. If your employment authorization document expires and the system doesn't immediately reflect an approved extension, your legal ability to work, and sometimes even remain, can be questioned. People are shocked to learn that working even a few days without valid authorization can create long-term immigration consequences. The emotional toll is devastating. Imagine waking up, going to work like always, only to discover that the document you depend on quietly expired, and now your job, your income, and your future are all at risk. Many affected individuals are not out of status by intention. They are caught between paperwork and policy changes. The most important protection right now is awareness. Knowing your exact expiration date, filing renewals early, keeping proof of submission, and never assuming silence means approval can make the difference between stability and crisis. In 2026, work authorization is not just permission, it's protection, and losing it can open doors no one wants opened. If this made your heart race, comment work permit and subscribe, because we work day and night to warn families before documents expire and lives are turned upside down with no warning. Number 3, criminal charges. One of the most misunderstood and frightening immigration triggers in California right now is this. You don't need to be convicted of a crime to face immigration consequences. As enforcement policies tighten toward February 15th, 2026, immigration authorities are paying closer attention not just to convictions, but to arrests, pending charges, and unresolved cases. For many people, this comes as a complete shock. They believe that if a case was dismissed, reduced, or never went to trial, it no longer matters. But under current immigration review practices, the record itself can be enough to raise red flags. This becomes especially dangerous because immigration law does not work the same way as criminal law. A charge that seems minor in state court, like a low-level theft, driving-related offense, or domestic dispute, can still be interpreted as a serious immigration issue depending on how it's classified. Even cases that ended with probation, fines, or no jail time can resurface years later when databases are rechecked. With newer data sharing systems, old police reports and court records are being pulled back into active review, even if your life has been clean and stable ever since. What makes this deeply unsettling is how often people were never warned. Many accepted plea deals just to move on, never knowing immigration consequences were attached. Others were arrested but never charged and assumed the incident disappeared. Now, as February 2026 approaches, those forgotten moments can suddenly feel very present. Immigration reviews don't ask how long ago it happened or how much you've changed. They ask what's on record. The safest step right now is not panic, but preparation. Knowing exactly what appears on your criminal and immigration history and understanding how it could be interpreted gives you power before enforcement begins. In today's system, silence and assumptions are riskier than the truth. If this shocked you, comment legal check and subscribe, because we put everything into protecting families from hidden records that can suddenly decide their future. Number 4, asylum cases stuck in limbo. For thousands of people in California, asylum was supposed to mean safety, not uncertainty. Yet, as February 15th, 2026 approaches, those with long pending or incomplete asylum cases may face some of the highest risks of sudden review and removal. Many applicants have been waiting for years, doing everything they were told, checking in, working legally, raising families, and trying to rebuild their lives. What they didn't expect is that waiting itself could now place them in danger. Immigration systems are shifting from patience to pressure, and cases left unresolved are being pushed back into the spotlight. The real problem isn't just delays, it's missed details during long waits, a single missed check-in, an address that was never updated, a notice that arrived but was never seen. Over time, these small issues quietly pile up. Under newer enforcement practices, asylum cases that appear inactive or inconsistent are being flagged for fast-track decisions. That means people who believed they were safely waiting could suddenly receive notices demanding action, or face consequences for things they didn't even realize were required. The system doesn't ask how scared you were, how long you waited, or how hard your life has been. It only checks whether every rule was followed perfectly. What makes this emotionally devastating is that many asylum seekers trusted the process completely. They were told to wait, to be patient, to let the system work. Now, patience alone is no longer enough. Immigration authorities are prioritizing case closure. And unresolved asylum files are being reviewed with fresh eyes and less tolerance for errors made years ago. The most powerful protection right now is awareness and engagement. Regularly checking case status, confirming addresses, attending every appointment, and responding to every notice, no matter how small, can mean the difference between protection and expulsion. In 2026, asylum is not just about fear of return anymore, it's about perfect compliance while waiting. If this fear feels real to you, comment asylum wait and subscribe, because we pour our soul into guiding people through a system where silence can cost everything. Number 5, Temporary protected status ending. For many families in California, temporary protected status, TPS, has felt like a lifeline. Something stable, something safe, something that allowed them to breathe after years of uncertainty. But here's the painful truth most people avoid thinking about. TPS was never meant to last forever. As February 15th, 2026 approaches, changes in designation reviews and enforcement priorities mean that expired or non-renewed TPS can instantly place people back into removal risk, even if they've lived, worked, and paid taxes in the U.S. for decades. The word temporary is no longer theoretical, it's becoming real. What makes this situation especially dangerous is how quietly TPS can end or change. Extensions don't always come with loud announcements. Deadlines can shift, eligibility rules can tighten. Many people assume that if they've been renewing TPS for years, the next renewal is guaranteed. It isn't. If a country's designation is terminated, or if an individual misses a re-registration window, even by mistake, the protection can vanish overnight. Once that happens, the system doesn't see your history or hardship. It sees someone without lawful status. The emotional weight here is enormous. TPS holders are often deeply rooted in California communities. They own homes, raise U.S.-born children, care for elderly parents, and work in essential industries. Yet all of that stability rests on a status that can disappear with a single policy decision or missed deadline. As enforcement systems become more connected, expired TPS records are being flagged faster and more efficiently. People who believed they were protected suddenly find themselves questioning everything: their job, their home, their family's future. The most important step right now is vigilance. Know your TPS expiration date, follow official announcements closely, and never assume automatic extensions will cover you. Explore backup options early, before protections end, not after. In 2026, TPS still offers protection, but only to those who stay informed and act on time. Waiting and hoping is no longer enough when the clock is this loud. If TPS is your lifeline, comment TPS status and subscribe, because we put our heart into helping families before protection runs out and lives are shaken beyond repair. Number 6, public benefits use. For years, people in California were told that using public benefits you legally qualify for would not harm your immigration case. And for many, that advice was true at the time. But as February 15th, 2026 approaches, public charge rules are being quietly reinterpreted, and this is where confusion turns dangerous. What once felt like responsible support during hard times, healthcare help, food assistance, housing aid, can now raise questions during immigration reviews, especially when applications are re-examined under updated standards. The danger is not that benefits automatically lead to removal. It's that many people don't know which benefits count and which don't. Some programs are protected, others fall into gray areas depending on timing, duration, and immigration category. Many families applied during emergencies, layoffs, or medical crises, believing they were safe. Years later, when records are cross-checked, those same applications can resurface without context. Immigration systems don't see the hospital bills, the job loss, or the pandemic. They see a benefits history tied to a name. What makes this emotionally heavy is that people did exactly what they were encouraged to do. They sought help, stayed afloat, protected their children. Now, as enforcement becomes more data-driven, benefits records are being reviewed alongside immigration files, sometimes triggering requests for explanations or additional scrutiny. For someone already on temporary status or waiting on a decision, this extra attention can feel like the ground shifting under their feet. Folks, the most important protection right now is knowledge and timing. Never assume past advice still applies today. Before applying for new benefits, understand how they may be viewed under current rules. Keep records showing eligibility, lawful use, and necessity. And if benefits were used in the past, don't hide it. Clarity is safer than silence. In 2026, help is still allowed, but not understanding the rules can quietly turn support into risk. If you ever accepted help to survive, comment benefits check and subscribe, because we give everything to make sure support doesn't become the reason families are torn apart. Number 7, missed immigration court dates. Few people realize this, but missing a single immigration court date can result in an automatic removal order, even if you had a strong case, legal representation, or valid protection at the time. As February 15th, 2026 draws closer, immigration courts are moving faster, tightening procedures, and showing far less flexibility for missed hearings. For many people in California, the danger isn't disobedience, it's never knowing a hearing was scheduled in the first place. Here's how it usually happens: a notice is mailed to an old address. Someone moves apartments but forgets to update their information. The letter arrives late or not at all. Sometimes it's written in legal language that's hard to understand, or it gets mistaken for junk mail. But immigration court doesn't see confusion or chaos, they see non-appearance. Once a judge marks someone as absent, an in absentia removal order can be issued automatically, often without the person even realizing it until years later. What makes this terrifying is that life doesn't stop while cases are pending. People are working, raising children, caring for family, and trying to survive. They assume no news is good news. But behind the scenes, cases continue to move, and hearings can be scheduled with very little notice. As systems become more digitized and enforcement more coordinated, old missed court dates are being rediscovered and acted upon. People who believed their case was still open suddenly learn they've been living under a removal order the entire time. The emotional impact is devastating. Imagine discovering that your chance to explain your story, your fear, or your eligibility for relief ended years ago because of one missed day you never knew about. The truth is, immigration court requires constant attention. Regularly checking case status, confirming hearing dates, and keeping addresses updated are no longer optional. They are critical. In 2026, missing court doesn't mean delay. It can mean goodbye. If this scares you, comment, court check, and subscribe, because we put our heart into warning people before one missed notice costs them their entire future. Number 8. Sponsorship collapse. One of the most fragile parts of the immigration system is something many people never think about until it breaks: sponsorship. For countless immigrants in California, legal status is tied directly to an employer, a spouse, or a family member. It feels secure until it isn't. As February 15th, 2026 approaches, enforcement reviews are paying closer attention to cases where sponsorship quietly ended, even if the person affected continued living and working as usual. A job loss, a business closure, or a relationship breakdown can instantly weaken a status that once felt solid. What makes this especially dangerous is how sudden and indirect sponsorship collapse can be. An employer shuts down after layoffs, a sponsoring business withdraws support without proper notice. A marriage ends in separation before paperwork is updated. In many cases, the immigrant doesn't immediately lose work or residency, but the legal foundation underneath them cracks silently. Immigration systems don't track emotions or personal circumstances. They track whether the sponsoring relationship still legally exists. Once it doesn't, status can begin to unravel, sometimes months or years later when records are reviewed. The emotional shock is severe. People plan their lives believing their status is independent, not realizing how dependent it actually is on someone else's actions. By the time they learn the sponsorship ended, the window to fix it may already be closing. As data sharing improves, gaps between sponsorship records and real-life situations are being flagged more quickly. Someone who thought they were compliant suddenly receives a notice questioning their eligibility to stay. The most important protection right now is awareness and preparation. Know exactly who sponsors your status and what happens if that relationship changes. If your job ends or your relationship shifts, don't wait. Explore alternatives immediately. Backup options exist for many people, but only if action is taken early. In 2026, your future should not depend on assumptions about someone else's stability. Understanding sponsorship rules now can prevent irreversible consequences later. If your status depends on someone else, comment sponsorship and subscribe, because we put everything into helping people protect their future before one breakup or layoff changes everything. Number 9, data sharing systems. One of the biggest changes most people never see but feel the consequences of is how immigration data is now shared and rechecked across systems. As February 15th, 2026 approaches, California and federal databases are working together more efficiently than ever before. This means old records that once sat quietly in separate systems are now being connected, compared, and analyzed. Something you believed was resolved, forgotten, or irrelevant years ago can suddenly resurface, without warning, during a routine review. This is where fear and confusion collide. A past visa overstay that was never corrected, an old address mismatch, a work authorization gap that seemed insignificant at the time. In the past, these details often stayed buried because systems didn't talk to each other. Today, automated cross-checks don't forget and don't forgive inconsistencies. If one system shows lawful presence and another shows a gap, the system doesn't ask why. It flags the file. And once flagged, human review often follows, sometimes with serious consequences. What makes this especially unsettling is that people didn't do anything new wrong. They didn't commit a crime. They didn't violate a new rule. The risk comes from technology catching up with history. Many immigrants built their lives believing time had closed old chapters, but with smarter data tools, time no longer hides mistakes, it highlights them. As enforcement becomes more data-driven, people are being questioned not about who they are today, but about what their records say from years ago. The emotional weight is heavy. Imagine being told your future is now uncertain because of something you thought was long behind you. This is why preparation matters more than panic. Requesting records, reviewing past filings, correcting inconsistencies, and keeping documentation ready can protect you before systems raise questions. In 2026, immigration enforcement isn't just about laws, it's about data. And those who understand their records before the system does are the ones most able to protect themselves. If the thought of your past being rechecked scares you, comment data check and subscribe, because we give our everything to help people face the system prepared, not blindsided. Number 10, the California protection myth. For years, many immigrants have believed in one powerful idea: California will protect me. Sanctuary policies, local protections, and supportive rhetoric created a sense of safety that felt real. And in many ways, it was. But as February 15th, 2026 approaches, one truth is becoming impossible to ignore. State protections do not override federal immigration law. California can limit cooperation, slow processes, and provide resources, but it cannot stop federal enforcement once someone is flagged under federal rules. This misconception has quietly placed many people at risk. Individuals assume that because local police wouldn't ask about status or because they lived in a sanctuary city, they were untouchable. That belief led to inaction, missed renewals, ignored notices, unresolved cases. But federal immigration systems operate independently, and when enforcement decisions are made at the federal level, state borders and policies offer limited shelter. As data sharing improves and enforcement becomes more centralized, federal reviews can proceed without local involvement at all. The emotional shock comes when people realize the safety they trusted was partial, not permanent. California can offer legal aid, warnings, and time, but it cannot erase immigration violations or stop federal agencies from acting on flagged cases. Many people learn this only when it's too late, when they're already in proceedings and asking why the protections they believed in didn't save them. The truth is painful but empowering. Understanding the limits of protection is the first step to real safety. The most important message going into 2026 is this: do not confuse comfort with compliance. Living in California reduces risk, but it does not remove responsibility. Federal law still decides who stays and who goes. Those who stay informed, proactive, and prepared are far safer than those relying on myths. In today's system, knowledge, not location, is the strongest protection you have. If you believe California alone could protect you, comment reality check and subscribe, because we put our heart into replacing dangerous myths with life-saving truth. As we reach the end of this video, one thing should be clear. February 15th, 2026 is not just a date, it's a turning point. What makes this moment so dangerous isn't a single dramatic law or headline-grabbing announcement. It's the quiet alignment of enforcement priorities, smarter data systems, and stricter interpretations of rules that many people thought no longer applied to them. For thousands living in California, the risk doesn't come from what they did yesterday, but from what they assumed no longer mattered. Throughout this video, we've seen a powerful pattern. Most people who face removal are not criminals or rule breakers. They are workers, parents, students, and caregivers who missed a deadline, trusted the wrong advice, or believed protection was automatic. An expired document, a missed court notice, a rise of sponsorship that quietly ended, a benefit taken in a moment of need. These are human mistakes, not malicious acts, but the system does not judge intent. It judges records, dates, and compliance. The most important takeaway is this: ignorance is no longer protection. In 2026, immigration enforcement is driven by information, not warnings. The people who are safest are not the luckiest. They are the ones who check their status, understand their history, and act before the system acts on them. Preparation creates options. Delay creates danger. Even small steps, verifying records, Updating addresses, seeking guidance early can change the outcome entirely. If this video made you pause, reflect, or feel uneasy, that reaction matters. Fear alone won't protect you, but awareness can. Share this information with anyone who might need it. 1. Talk openly. Ask questions. Stay engaged, because in a system that rarely gives second chances, the strongest defense is knowing the truth before it's enforced.